So happy Constitution Day. Good afternoon. I'm David Ferriero, the Archivist of the United States, and it's a pleasure to have you here in the William G. McGowan Theater. And a special welcome to those of you who are joining us on our YouTube channel. Today we'll take a look at our Constitution with a member of the United States Senate who believes that it has been subverted and needs to be restored to what the Founding Fathers created in Philadelphia in 1787. Senator Mike Lee of Utah is here to talk about the concerns raised in his book, Our Lost Constitution, the Willful Subversion of America's Founding Document. Before we go any further, I'd like to tell you about several programs coming up here in this theater. Tonight at 7, join us for our Constitution Day program, The Young Madisons, Why a New Generation is Standing Up for the Constitution. It will feature a panel representing a new generation of civic leaders shaped by the digital revolution that is reaffirming its commitment to the rights-based principles of the Constitution. This discussion will be the 9th annual State of the Constitution lecture at the National Archives, presented in partnership with the Robert H. Smith Center for the Constitution at James Madison's Montpelier. The lecture focuses on the voices of young leaders who are shaping America's future as a constitutional democracy. And on September 23rd at noon, we'll host historian Irwin Gelman, who will discuss his new book, The President and the Apprentice, Eisenhower and Nixon, 1952 to 1961. The author reveals the strong relationship between Eisenhower and Nixon and discusses how Ike's presidency worked and what it accomplished. Ike trusted and relied on Nixon and sent him on many sensitive overseas missions. If you want to know more about these and all of our upcoming events and programs, please refer to our monthly calendar of events. There's a sign-up sheet in the lobby where you can receive it by email or in regular mail. In Our Lost Constitution, Senator Lee argues that since the Constitution was ratified in 1789, key provisions have been ignored and distorted through legislation in Congress, decisions by the Supreme Court, and regulations issued by agencies and departments. They include, for example, the provision that all tax bills originate in the House of Representatives. Today, many a tax bill in practice originates on the Senate side of the Capitol. Joseph Postel, writing about the book in the National Review, says that it is fundamentally about the strange fact that we live under a Constitution that is still ostensibly in effect and still revered by most Americans, but has been circumvented time and again in practice. In American Spectator, Mark Pulliam writes, with interesting profiles and colorful anecdotes, Lee provides an engaging history lesson for each of his lost clauses and explains the public policy significance of the Supreme Court's departure from the text of the Constitution. Please welcome Senator Mike Lee.
Thank you very much, David. Thanks to all of you for being here. It's a real honor to be here at the home plate of the Constitution, the base of the Constitution, to speak on Constitution Day about the Constitution. It is a real honor for me to be here with you. I've been in the Senate now for about 4.5 years. It's been an interesting ride. When I first arrived in the Senate, I was the Senate's youngest member. I was 39 years old at the time. So I cleared the constitutional threshold by a full 9 years at the time I was elected. Nonetheless, I was the youngest member at the time I arrived. And in order to make myself sound older and then make myself feel like I fit in a little bit better, I started telling my colleagues that even though I was only 39, I was reading at the level of a 40-year-old. They weren't all that impressed, but the age differential manifested itself in many ways. Among other things, the security personnel didn't seem to recognize me. Part of that was just a function of the fact that I was new, and part of it was that I guess I didn't look very much like a senator. And it was a new experience for me because as a non-drinking kid from Utah, I'm not used to being carded. And yet this is what was happening to me nearly every time I went into the Senate chamber to cast a vote. These heavily armed, burly gentlemen who guard the doors to the Senate would look at me almost as if to say, you know, the door for the staff is over there. And they didn't want to see my driver's license. I'll even show you what they wanted to see. They wanted to see my Senate ID. I'll show you the card. It says that I'm a United States Senator representing Utah. It has my picture on it, not very impressive. And then there's this sort of jarring statement at the bottom of it in the fine print that says expiration January 3rd, 2017. I had to assure my wife Sharon and our 3 children, who told me to tell you hello, by the way. The archives, their favorite place to visit in Washington. Had to assure them that January 3rd, 2017 was not the day I personally expire. It's just my term of office. But they would sit there, the police guarding the Senate chamber, and they'd actually examine the card so as to make sure that I hadn't bought it at a fake ID outlet in Georgetown. And they'd look at each other, they'd shrug their shoulders, and they'd say, oh, I guess we have to let him in. And after this went on for a few months, I was talking to one of my colleagues about it who said, you know, that lapel pin that they gave you serves a purpose. It's there to help them know that you're a senator. And I said, why is that? Well, they said, the only people who wear those are senators. I had forgotten about the lapel pin. I'm not really into accessories, so when they gave it to me after I was sworn in, I had put it in a desk drawer, and then I closed the drawer and forgot about it. Ever since then, I put the pin on, and I've worn it, and it works like a charm. I refer to it affectionately. I've given it a nickname. I call it my sorry senator pin, because when they card me, I point to the pin, and they say, sorry, Senator, you can come on in. And it works most of the time like a charm, but occasionally it doesn't. After I had been in the Senate for nearly a year, one time I was on the floor of the Senate, I was casting votes. We were in between 2 or 3 roll call votes, and each of these votes takes about 15 minutes to complete, and I had one arm gently resting on the desk in front of me, thinking about how the vote was going to turn out, and one of the non-uniformed security guys inside the Senate chamber came up to me and says in a very harsh tone of voice, excuse me, will you please not lean on the senator's desk? And I said, oh, I'm terribly sorry, it won't happen again. You know, I thought it was weird that he referred to it as the senator's desk and not your desk or whatever, but you see, they're very protective of the desks, because a lot of the desks in the Senate chamber are original equipment, which means a lot of the desks in the Senate chamber are about 150 years old, which means a lot of them are about as old as some of my colleagues, and guard them very, very jealously. And then he said, are you with the minority? Referring to the minority party. Republicans were then the minority party in the Senate. And I said, well, yes. I'm not sure whether you mean, am I voting with my party this time or on the next vote? He said, no, are you with the minority leader? And I said, well, Mitch McConnell is our leader. I don't understand the question. He said, are you part of the minority leader's staff? And then I realized, okay, he doesn't know who I am. And so I just pointed casually to the sorry senator pin. It didn't work. All I got was a blank stare. And so I realized then and there I was going to have to do something I didn't like to do, still don't like to do. I was going to have to use my title. I don't like throwing the title around. It makes me uncomfortable. And so I kind of mumbled it, and I said, I'm Senator Lee. And he said, what? And I said, okay, my name is Mike Lee. I come from a state called Utah, sort of like a square, lovely skiing in the Rocky Mountains, and I'm a senator from there. And only then did he realize who I was, and all the color seemed to drain from his face as he told me in one hurried breath, I'm terribly sorry for the misunderstanding, sir. My name is Steve, if you want to report me. And then he ran for the door. But this was an honest mistake. And so I chased after Steve to tell him it was no big deal, but he was too fast. And so from then on, every time I pass Steve in the halls of the Senate or the Capitol building, I say, hi, Steve, and I wave to him, and I smile just so he knows there are no hard feelings. And we joke around. And only recently did it occur to me, his name's probably not Steve. Yeah. I'm pretty sure it's Bob. Steve's probably a guy he works with that he doesn't like. I didn't want to have to assert my right to be there that day in the way that I had to assert my right to be there that day, meaning I didn't want to have to use my title. It made me uncomfortable. But had I not done so, I might have found myself being removed from the Senate chamber and unable to vote that day. The 3 million people I represent in my state wouldn't have been represented by me that day. I would have lost something meaningful had I not asserted that which was rightfully mine, that which I worked for very hard in 2010 in getting elected to the Senate. Sometimes this applies to all of us, not just as U.S. senators, not just as people who hold public office, but all of us as U.S. citizens have certain things that are rightfully ours, that while rightfully ours will cease to be meaningful unless we continually assert them. And there are many rights under the Constitution that we understand sufficiently well as a society and that are sufficiently honored and respected, revered, and followed as a society that we can reasonably hope and expect our government officials will follow them. Most of the time, for example, if you get pulled over for a speeding infraction, the officer is not going to ask you for proof of where you went to church on Sunday. If that ever does happen, please call me. That's a problem. They can't do that. You probably are not going to be arrested if you advocate for a cause or a candidate of your choice. The First Amendment would prohibit that too. If that ever happens, please call me. They can't do that. But there are other rights under our Constitution that aren't always as obvious. And for our rights to be meaningful, for us to be able to assert them, we have to be able to understand them. For us to be able to fully understand them and appreciate them and be passionate about them enough that we can and we will assert them and protect them and defend them. Sometimes it's helpful for us to know the stories behind those provisions of the Constitution, to be able to put them in historical context so that when we see a constitutional violation, we recognize it. Not only will we recognize it, but we'll see and feel at a visceral level the importance of asserting that right. So I'd like to talk to you today about a few of our rights in the Constitution, some of which I have addressed in my book, Our Lost Constitution, which came out in April. By the way, all 12 people who have read it so far have really enjoyed it. These provisions that I discuss in the book are provisions that are more or less known to the public or known to the public to one degree or another, but that we can more fully understand if we know the stories behind them. I learned from my own parents the fact that when they told me a story behind something, in many cases it was a provision of the Constitution, I would learn about it more fully. The Constitution was something that we discussed in our household. When I was a child, my father was a professor of constitutional law, and I didn't realize that that was unusual. I think I was 30 before I realized not every family discusses the presentment clause over dinner. But it is nonetheless the kind of discussion that we as Americans of all political persuasions, of all backgrounds, need to be having these kinds of discussions because they make our public discourse and dialogue more robust. And to the extent we understand these provisions, we will defend them and we will assert our rights under them, and they will be more meaningful to us. The first of the provisions I'd like to discuss with you today is the Fourth Amendment. The Fourth Amendment has a long and storied history and tradition in America, one that predates our existence as a country. The interests protected by the Fourth Amendment can, in many respects, be traced back to a man named John Wilkes, who was a member of Parliament in the mid to late 1700s. John Wilkes was a patriot. He loved his country. He even loved his king, even though he was inclined frequently to criticize his king. At the time John Wilkes was serving in Parliament, it had become common to have these political news magazines called weeklies. Weeklies were frequently read in taverns and saloons and homes across England, and these weeklies would discuss the public affairs of the day. In many instances, they would discuss the policies of the Parliament and the king. In some circumstance, they would even be critical of certain policies. But they had a certain rule. There was a certain almost unwritten rule. You don't ever criticize the king. You might criticize his ministers. You might criticize one or more policies, but you never, ever criticize the king or even come close to it. It just isn't done. John Wilkes eventually became bored with the weeklies that were popular in England, the most prominent of which was known as the Briton. And so in an act of symbolic protest against what he saw as a lackluster political debate, he started a new weekly, which he called the North Briton. It was kind of an alternative voice. The North Briton, over time, became increasingly critical of the regime of King George III, of some of his policies. And eventually, with the publication of North Briton number 45, the administration of King George III decided that John Wilkes had crossed a line. With the publication of North Briton number 45, John Wilkes found himself under arrest. He was arrested because of his involvement in this. Now, the interesting thing about how this was carried out was that the arrest warrant and the warrant to search Mr. Wilkes and his home never named John Wilkes. It never specifically identified him, either by name or through any other indirect means. It simply said, go after and search and seize everyone and everything related to the publication of the North Briton. Go after it, go find it. This was an approach that was referred to as a general warrant. It was the kind of thing that had already been outlawed in Great Britain. It was against the law. And John Wilkes knew this, even though he also understood that in many instances, the wielding of executive power is a little bit like the holding of property, in that possession is 9/10 of the law. He knew that he was not in a favorable position of bargaining power, and yet he also understood that he needed to assert his rights. He argued quite aggressively in court and eventually won his release from jail. He was released, and he also was very upset still, notwithstanding his release, over the fact that his home had been searched pursuant to this general warrant. Every door had been opened, every drawer had been searched. All of his most personal papers had been rummaged through by government officials. He understood that this was unfair, that it was a profound injustice under the laws of England at the time. And so he decided he wasn't content with simply winning his freedom. He decided that he was going to challenge the validity of that warrant in court. And what that meant under the laws of England at the time was that those who conducted this search of his house could actually be held liable. He could have a valid tort action against them. He could recover damages against them if he could prove that they acted unlawfully, if he could prove that this warrant was invalid, that it was unlawful. He brought his case to court, and recognizing that initially, when he was released, he wasn't released under the idea that the general warrant was invalid, because the judge who handled the case chose to deal with it on a technicality. As a matter of parliamentary privilege, he ordered the release of John Wilkes. So in his civil case, he argued very aggressively and ultimately victoriously that the officials who conducted this search had acted unlawfully because the warrant itself was invalid. At the end of the day, he was awarded £4,000 in damages, a tremendous sum, equivalent today to, I believe, somewhere well into the six figures in terms of present-day dollars. But that victory, the financial victory, the economic component of the victory, was only the tip of the iceberg as far as what it meant. You see, because in the course of winning his freedom initially from being jailed, and then in the course of successfully trying his civil action, John Wilkes became a folk hero in England. The name John Wilkes became synonymous with freedom, with liberty, with resisting oppression throughout all of England. People celebrated the case of John Wilkes by putting lighted candles in their window. And you couldn't go within 15 miles outside of London without seeing candles lit in every window. Even people most loyal to the king had a lit candle in their window for fear of being the victims of a pro-John Wilkes mob. The number 45, representing the North Briton 45, the offending publication, became a symbol of this resistance movement. This would be the equivalent to some of the things that you saw if you read the Hunger Games series, people resisting an oppressive government. And so all over England, the number 45 was written on the doors of taverns, of saloons, on the doors of carriages, and of homes. People celebrated the number 45 by buying drinks for 45 people in their local bar. The number 45 became synonymous with John Wilkes, and the name John Wilkes became synonymous with the cause of liberty, initially in England, ultimately in America as well. We have counties and cities and towns that were named after John Wilkes during the American colonial period, honoring his contribution to the cause of liberty. Interestingly enough, the judge who ruled in his favor was later given the title of Lord Camden. And that, interestingly enough, was the name given to the railroad intersection that later became Camden Yards, where the Baltimore Orioles play. So Lord Camden even also became famous as a result of this struggle. People everywhere understood that John Wilkes represented each of them, that if his liberty was threatened by the use of general warrants and by the indiscriminate searching of homes without specifically identifying the targets to be searched and to be seized by the warrant, that no one was free. Thus, John Wilkes became the everyman around whom people rallied on both sides of the Atlantic. Shortly after the Constitution was drafted and gaining momentum after the Constitution's ratification, there came a great call for a Bill of Rights, and everyone understood that among the Bill of Rights we needed some type of protection from the use of general warrants. And that ultimately is where we got the Fourth Amendment. That ultimately is why we have a part of our Constitution that says that no warrants shall issue except on an evidentiary finding of probable cause, and that you have to identify the names of the people subject to the warrant. You have to identify them with sufficient particularity that there is some semblance of due process attached to the entire thing. And so we have a lot to be grateful for when it comes to John Wilkes. Well, how is this relevant today? In a sense, we live in a world where general warrants are not entirely unfamiliar. At least there is something that's been in use for many years now that in many ways resembles a general warrant. I note in my book that the NSA has, over the last decade or so, been collecting data on the telephone calling patterns of the American people, collecting records on the origin, the destination, the time, and the duration of every call made by every American. And the NSA has kept those records for a period of 5 years at a time in a large database that can be searched. Now, a lot of people point out that in this program, which is known as the Bulk Data Collection Program, carried out pursuant to Section 215 of the USA Patriot Act, they point out that under this particular program, the NSA is not collecting the substance of these phone calls. In other words, it's not listening to the calls, it's not recording the calls, at least not under this program. It is collecting only what they call the metadata, the origin, destination, the time, and the length of each call. But if you think about it and you unwrap all of this, you realize that this is not something that is entirely innocuous. It's certainly not something that can't be abused. Over time, your calling patterns reveal a lot about you. Imagine, for example, how many people you have called or have called you over the last 5 years. For most of us, I would say it's at least 1,000, maybe in the many thousands for people who are heavy telephone users. And so if they have access to everyone you've called, everyone who's called you, the time the call has occurred and the duration of the call, and they can put it into a big database, they can tell all kinds of things about you. And in fact, with the proper data analytics tools, in many cases, they can figure out your age, your sex, your political leanings, your partisan affiliation, what is the condition of your health, what health ailments you might suffer from, and what your hobbies are, all kinds of things about you, things that are frankly none of the government's business. All of this is done pursuant to a court order that doesn't specify, doesn't provide with particularity for things to be searched or things to be seized. It just says, telephone company X, send us your calling records. We want them all. It's been storing them in a large database. Now, a lot of us think that this is at least closely analogous to a general warrant, and a lot of us think this is wrong. This is also the kind of issue that I believe is neither Republican nor Democratic. It's neither liberal nor conservative. It's simply an American issue. It's an issue that's closely tied, closely connected with the rule of law. That's why I joined together a couple of years ago with my friend Pat Leahy. Now, Pat Leahy is a liberal Democratic senator from Vermont, and I'm not. But he and I both share a passion for the Constitution. We share a passion for the Fourth Amendment. And we both share the belief that the NSA's bulk metadata collection program, carried out under Section 215 of the Patriot Act, violates at least the spirit, if not also the letter, of the Fourth Amendment. It was a tough battle. We had opponents in both political parties and in both houses of Congress. But I'm pleased to say this is one instance where talking about the Constitution, talking about the stories behind the Constitution, talking about the reasons why the Constitution matters, why the Constitution is a good in and of itself, and why it's a good that needs to be protected, if nothing else, for the sake of the rule of law. How that kind of cause can ultimately bring about good fruit. Ultimately, we succeeded, and a couple of months ago, we passed the USA Freedom Act, which is bringing about an end to the bulk collection of metadata pursuant to Section 215 of the Patriot Act. I thank John Wilkes for his contribution to that, and I'm reminded frequently of the number 45. And the number 45 has special meaning for a lot of reasons, not only because of North Britain 45 and all it represents with John Wilkes, but I kind of like the number because Utah happens to have been the 45th state admitted to the Union. The next part of the Constitution I'd like to tell you about does not rely on a specific provision of the Constitution, but on the Constitution as a whole, the structure of the Constitution. One of its most important protections has to do with the way that the Constitution separates power. The Founding Fathers understood that human beings are fallen. They're subject to potential corruption, but they're redeemable. In other words, human beings aren't inherently evil, but if given power, and if that power is allowed to remain unchecked, eventually they are prone to abuse it. For that reason, they knew that they needed to check power. And then they needed the power to make and implement and enforce law. They needed to make the processes by which those things are carried out subject to the popular will of the people and not insulated from the will of the American people, from the public. Now, this today is something that in many ways we take for granted because we've all been raised in a country where this is the case, and this has been the case for a very long time. But even at the time of the American Revolution, this wasn't necessarily something that everybody took for granted, that everyone assumed would always be the case. In fact, even at the Constitutional Convention, there was some debate as to whether or not those who made and enforced our laws would always be subject to elections. Alexander Hamilton had an interesting take on this. And in telling you the story about Alexander Hamilton, I want to start with a story that occurred many years prior, about 12 years before the Constitutional Convention. In May of 1775, Alexander Hamilton was a young man living in New York, and he was awakened in the middle of the night by a friend. And this friend was there to tell him that someone they knew was in trouble. Miles Cooper was the president of King's College at the time. He was a well-known supporter of the king. He was loyal to the king. And for that reason, he was unpopular with the Sons of Liberty. He was unpopular with a lot of people who were for the revolution and who were not loyal to the king. He received word in the middle of the night that President Miles Cooper was under attack and that there was a mob that was attacking him and that was trying to tar and feather him. At that moment, Alexander Hamilton went out, and although there was no greater American patriot, no more staunch supporter of the revolutionary cause than Alexander Hamilton, he didn't want this mob to do violence to Miles Cooper. He knew that that would be wrong. And so he went out there and put himself at great risk, not only reputationally, but also potentially physically, in order to stop the mob from tarring and feathering Miles Cooper, or even doing much worse. At the end of that, he was able to convince the mob not to do it. They left him alone. He was able to go back to bed that night. He was able to rest comfortably. But I think that episode, among others that he saw, caused Alexander Hamilton to have a certain distrust for mob mentality. And this may have influenced the fact that 12 years later at the Constitutional Convention, Alexander Hamilton actually stood before his colleagues, years after we had won the Revolutionary War, stood before his colleagues when discussing what kind of government we wanted. And he proposed a monarchy. He actually proposed that we have an elected monarchy, that we choose the monarch. Once the monarch was in place, we would have a monarch for life, for the period of that person's life. He gave this speech for a period of 2 hours on June 18th, 1787. I can only imagine the hot, humid, sweltering summer of 1787 having to sit there and listen to him for 6 hours. It wasn't until he was 3 hours into his speech that he explained to them where he was going. Up until that point, he had dropped little clues here and there, talking about the risk of mob rule, talking about the bad things that can happen when the will of the mob isn't checked in any way. And then the zinger came 3 hours into it. I think we should have an elected monarch. Now, as you might imagine, it didn't exactly go over well. In fact, it went over like a lead balloon. It came down with a thud, and a lot of people were shocked. They didn't like it. In fact, there's been a lot of speculation that this completely destroyed Alexander Hamilton's chances of being president, in part because many believe that's why they put the birthright citizenship requirement in the Constitution, was to prevent Alexander Hamilton from ever becoming president of the United States, specifically because he gave this speech. They didn't trust him. But the reason he gave that speech was because he didn't trust the mob. The reason they rejected that speech was because they didn't trust what a monarch would do. After all, we had just won a revolution against a government headed by a monarch. They saw that as the last thing we wanted at the time. It's one of the reasons why they were so careful at the Constitutional Convention to parse out the different powers of government, to separate them out, and to make sure that those in charge of making the laws would stand accountable at regular intervals to those they represented. It's one of the reasons why we ended up not just with an elected legislative body, but an elected legislative body consisting of 2 chambers. They wanted to make doubly sure that there was accountability at every level within our lawmaking system. So how's that story relevant today? How does that matter now? In some ways, we've reverted to a system that operates, at least to a significant degree, on the basis of people who are immune from the vote, from the voter, from the American people. Let me explain what I mean. I have 2 stacks of documents in my office, in the Russell Senate Office Building. If you're up there, you're welcome to come see it. I'm in room 361A of the Russell Senate Office Building. 2 stacks of documents that illustrate the point that I'm talking about our laws. One stack of documents consists of the laws passed by Congress last year. The people's elected representatives in the House and the Senate agreed, and the President signed them into law. It's a few hundred pages of law passed last year. It's only a few inches tall. It's a small stack of documents. The other stack, by comparison, is huge. It's, instead of just a few inches tall, it's 11 feet tall. Instead of a few hundred pages in length, it's 80,000 pages in length. And this second stack of documents consists of last year's Federal Register. Now, for those of you who are blessed sufficiently to not know what the Federal Register is, it's the annual cumulative index of federal regulations as they're released for notice and comment and later as they're finalized. 80,000 pages. Now, these are regulations that are promulgated. Now, I want to make clear, they're promulgated by men and women who are, by and large, very well educated, very well intentioned, very hardworking, and usually have a very high level of expertise. They have a lot to offer. I don't mean to disparage or denigrate in any way the hardworking men and women who work in our federal agencies and who promulgate these rules and regulations. But they have one thing that members of Congress do not and never will. They're not elected. And they therefore don't stand accountable to the voters at regular intervals. Not now, not ever. They're not really even directly accountable to anyone who is, in turn, elected. This creates a problem. It creates one of the same problems that the Founding Fathers fought so hard against at the Constitutional Convention. One of the problems they were so concerned about was this one. It's interesting. When I was in law school, about 20 years ago, I remember we had a guest speaker who came to speak to us about the growth of the modern regulatory state, the modern federal regulatory state. He explained to us that this regulatory system creates some problems. He may have mentioned the lack of accountability of federal bureaucracies, that issue rules carrying the force of generally applicable law. What he focused on most directly, most acutely, was the fact that the federal regulatory system was costing the American economy $300 billion a year. I remember when he said this, there was an audible gasp from the room. People said, $300 billion, that's an enormous amount of money. He went on to explain that this operates kind of like a backdoor invisible tax. Only it's a really regressive backdoor invisible tax, one that tends to afflict the poor and the middle class more than anyone else, even though they may not know it, even though they may not attribute the fact that it costs them money to the existence of the federal largesse in this area. Because these federal regulations make everything the American people buy more expensive. Goods and services that they purchase are made more expensive. The poor and the middle class feel that more acutely. Others may pay for those costs also in terms of diminished wages and lack of employment opportunities. But he explained that we needed reform. Now, that was 20 years ago. $300 billion a year was shocking at the time. Annual compliance costs, the cost of complying with federal regulations today, is nearly 7 times that. It now stands at about $2 trillion a year. This makes everything the American people buy more expensive. And these are rules that are put in place by men and women who, however well-intentioned, hardworking, and well-specialized and well-educated they are, don't work for you. They don't report to you. You can't fire them, ever. Now, lest I paint Congress as a victim here, I want to make clear Congress is not a victim. Congress, in fact, is the problem. Congress has created this problem. It has done so under the direction of Republicans and Democrats alike over the last 80 years. And it has done so by passing really broad, vague, amorphous laws. So imagine, for example, if Congress decided that it didn't want to do its job anymore, that members of Congress found political accountability to be so difficult that Congress wanted to just sort of escape any public criticism, and therefore passed one central law that said, we shall have good laws. And we hereby delegate to the herewith created Federal Commission on the Creation of Good Laws the power to make rules carrying the force of generally applicable law, that the herewith created commission will also have the authority to enforce and implement. And then Congress says, that's it, we're done. From that moment forward, Congress avoids any accountability for federal law. When people come and say the Federal Commission on the Creation of Good Laws has fined us, has treated us harshly, has come up with these horrible rules, members of Congress would say, oh yes, those barbarians over at that commission, they're just awful, aren't they? Let's talk about our common hatred of the people on the commission. Congress would escape accountability, and of course the commissioners have no accountability because they're not elected. They're not really accountable to anyone who is elected. Now, this may sound like a far-fetched example, but it's not all that far-fetched because it's what Congress does all the time. There are a lot of good legal and regulatory structures that in one form or another probably ought to be in place, but have been put in place the wrong way. Like, for example, the Clean Air Act. Congress, this is a bit of an oversimplification, but it more or less proves the point to say Congress passed a law saying, in effect, we shall have clean air. We hereby delegate to the EPA the task of explaining what clean air is, what pollution is, and then punishing polluters, defining the penalties that will apply. All of those things then belong to EPA. With some regularity, I have constituents coming to me explaining how this or that regulation, promulgated by EPA or another agency, is harming them. And members of Congress, at the end of the day, like to complain also about the agencies, never acknowledging that we ourselves are the problem. We ourselves created the problem. Fortunately, here, as with the Fourth Amendment example I pointed to a minute ago, there is a solution. This one hasn't been enacted yet, but it needs to arrive. The solution is actually quite old. It's about as old as the modern federal regulatory state itself. You see, James Landis, the famed law professor who was part of FDR's brain trust, who helped create the modern regulatory administrative state, advised President Roosevelt at the time that a lot of these agencies were first created and this type of lawmaking first became fashionable. He said, in order to really make this work within our constitutional structure, these regulations, the regulations that impose affirmative obligations on the American people, need to be passed into law by Congress. They need to be treated more or less as legislative proposals that once passed by the House and the Senate and signed into law by the President can take effect. Well, Congress, for whatever reason, never adopted that rule. James Landis's advice was overlooked in the 1930s. Congress drifted away from this. Congress left itself a back door by creating what's known as a legislative veto. And initially what were, to begin with, just a few provisions of federal law, over the next few decades became hundreds and hundreds of provisions of federal law, where Congress would say, okay, we give agency X the power to promulgate regulation Y, go do it, but if we don't like regulation Y, Congress can veto that. That became a favorite tool of Congress, and it made it even easier for Congress to rely on the outside rulemaking, outside lawmaking task. And over time, Congress became addicted to these. There was one problem. The Supreme Court came along in 1985 in a case called INS v. Chadha and declared the legislative veto provision unconstitutional, concluding that it violated Article 1, Section 7 of the Constitution, which contemplates that any new law has to be passed by the House and passed by the Senate and submitted to the President for signature or for veto, and that the legislative veto provision contemplated an additional loop in the circuit, one that didn't conclude with the President and was therefore unconstitutional. A lot of people thought or speculated or wondered at the time INS v. Chadha was decided whether that would mean perhaps the end of this excessive regulatory lawmaking. That maybe since Congress no longer had the last word, that Congress could no longer veto legislatively any executive branch regulation, that perhaps that would be the end of the party, at least prospectively. Turned out it was not the end. It was not even the beginning of the end. It was only the end of the beginning. Since then, we've had a lot more of this wholesale delegation of what is essentially legislative authority. We can point to laws passed in the last few years, including the Dodd-Frank Financial Regulation Act, including the Patient Protection and Affordable Care Act, each of which had many, many hundreds of instances of delegation of broad lawmaking authority to executive branch agencies. Here again, both Republicans and Democrats have done this. But here again, Republicans and Democrats are the victims of this. This harms the American people. Unfortunately, there is a fairly simple legislative solution, going back to what James Landis recommended back in the late 1930s. It's been reduced to a legislative proposal called the REINS Act, R-E-I-N-S. It stands for Regulations in Need of Scrutiny. It's been passed by the House of Representatives for the last 3 years in a row, has not been voted on the merits in the Senate yet, but it needs to be. Here's what the REINS Act says. It takes James Landis's recommendation, and it says, for every new federal regulation that the OMB deems to be economically significant, that regulatory rule will be deemed as a legislative proposal that may take effect if and only if the House and the Senate pass it and the President signs it into law. The important thing to remember here is that it's not that members of Congress are any smarter than the people who work in the executive branch agencies. If anything, they're far more smart than we are. They're far more specialized than we are in their respective fields. The difference is we work for the people. We stand accountable to the people. You can fire us every 2 years in the case of representatives, every 6 years in the case of senators. And we've learned from our common experience that it works much better when the people are in charge, when the people are the sovereigns, when the people have ultimate decision-making power as to the direction of their government. This George Washington concluded in the fall of 1787 after the Constitution was drafted but prior to its ratification. This would be the ultimate protection of our constitutional liberties. He said the power will always be in good hands. It'll be in the hands of the people. The people will discover from time to time that the Constitution is not being implemented in a manner consistent with their wishes. And whenever that happens, it'll be the right of the people to see that their elected representatives are recalled and replaced with others who will more closely reflect the wishes of the people. That's the genius of our system. But it can operate only to the extent that we understand it, that we know the stories behind it, and can therefore recognize when it's being violated, either in letter or in spirit. In this case, I think it's both. in this case, I think the American people can have the ultimate word, and ultimately they will. In conclusion, I want to end on a positive and an optimistic note. We as Americans, I think, will find that even though we suffer from a lot of problems, many of which are inflicted by the government itself, I think we're going to find that our best days remain yet ahead of us. I say that in part because of an optimism that I gained from reading a quote by Winston Churchill, who many, many decades ago said that the American people can always be counted on to do the right thing after they have exhausted every other alternative. We have experimented with a lot of experiments, a lot of designs around the Constitution, a lot of attempts to circumvent the Constitution. Those experiments haven't always gone so well. We've given them a nice long try. And I think we're returning to first principles, Democrats and Republicans alike, because we know that the Constitution works well to the extent that we follow it. When we look back to the event that occurred in Boston in December of 1773, it's an important time to remember. This moment when you had these American patriots who were still British subjects who decided that they would board a ship, and in an act of symbolic protest against the kind of national government they did not want. Their national government, of course, being based in London, not Washington, D.C. Washington, D.C. didn't exist then. They were opposed to certain things their large, distant national government in London was doing to them. It was taxing them too much. It was regulating them oppressively. It was doing so from afar. It was so far from the people in America that it was slow to respond to their needs. It wasn't accountable to them. And they took this tea, and in this act of symbolic protest against the kind of government they did not want, they destroyed the tea, English tea, by throwing it into the harbor. Had they stopped there, had they done no more than that, what we now refer to as the Boston Tea Party would at most be an obscure footnote in American history. But fortunately, they didn't stop there. They channeled their energy in a constructive and productive way. And it took them 14 years, but they went from Boston in 1773 to Philadelphia in 1787. And over that 14-year period, they declared and fought for and won their independence. And ultimately, in that summer of 1787, the Constitutional Convention, the conclusion of which we celebrate today, the Founding Fathers came together and they rallied together around a set of ideals about what they wanted their government to look like, what they wanted it to be like. It took them 14 years to go from Boston, where they started by protesting against the kind of government they did not want, to get to Philadelphia, where they embraced the kind of government they did want. Today, we have a similar task. It's a task that needs to be completed a lot faster than that, and it can be. We don't have to fight a war of independence. We don't have to fight a war at all, at least not a traditional war. But we do need to engage in a robust, roiling discussion about the kind of government we do want. In many respects, the kind of government we do want is still the kind of government that is described in that document, a document whose creation we celebrate today. That document that I believe was written by the hands of wise men. Not just any wise men, but wise men, I think, who were raised up by their Creator to that very purpose. That document that has fostered the development of the greatest civilization the world has ever known. It's my hope, and indeed my expectation, that we can take our own journey from our own Boston moment to Philadelphia, where we can come together once again as Democrats, as Republicans, as liberals, as conservatives, as Americans from every background around the cause of the kind of government we do want. Thank you very much. May God bless the United States of America. Okay, I'd love to answer any questions you've got. It can be about the Constitution or law or politics or Washington or relationship tips, fashion advice, rock music lyrics, anything you want.
Hi, can you hear me?
Yeah.
Sure. I have
Tell me
no
your name.
doubt that everyone in this room 200 years ago would say now that they would be opposed to slavery if it was decided. But I'm not sure whether that would actually be the case, right? Because there were certain economic incentives for having slavery and other religious reasons why people justified slavery. But maybe it would be more fair to ask what would happen, and we know the consequences of slavery, like 200 years later, the aftermath of slavery is still with us, right? So what is it that's going on now that in 200 years, if we can anticipate something that's going on now that's going to have severe consequences on our future, if we anticipate that and try to legislate because of that in order to, let's say, slow it down or reverse it, do you think of anything that's going on now that in 200 years we'd be better off because we're doing it now? Something that has to do, like when you talk about, the economy and how we would be severely impacted if we do certain things now, but that could possibly prevent something in the future, let's say, agriculture from being decimated by heat or shores from being inundated by water. Is there anything that you might think of now that you could do that could prevent that from happening?
Sure. A couple of things come to mind right off the bat. One is an issue that relates to our federal criminal justice system. Our federal criminal justice system has seen some changes in recent decades. And since 1980, we've seen our federal prison population explode. It's increased nearly tenfold. This does not reflect a tenfold increase in the commission of crime in America. It does, however, reflect a few trends. One involves the over-criminalization of the law generally. Another involves the over-federalization of criminal law. And yet another involves excessive reliance on minimum mandatory sentences within the federal sentencing system, such that we're putting a whole lot of people in prison for a really long time. As my friend Cory Booker often explains and has taught me, there are some severe racial disparities within that compound how troubling this can be. And in some communities in America, you've got a huge percentage of the population, particularly the male population, that finds itself in prison. Now, I'm not saying that I'm always against minimum mandatory penalties, but in many cases they're excessive. Let me give you an example. There was a man sentenced to 55 years in prison a few years ago, a man in Utah. He sold marijuana 3 times over a 48-hour period in relatively small increments. He happened to have had a gun on his person at the time of those sales. And the way that the federal laws interacted with each other, it caused this cascading series of minimum mandatory penalties to kick in, where the guy got sentenced to 55 years in prison for 3 sales of pot, relatively small sales.
And in 200 years, that would have an impact on us.
Yes, a huge societal impact as we continue to put this many people in prison, a lot of people in prison, sometimes for decades at a time, for offenses that might not warrant it. This can cause all kinds of problems in society. Let me give you another example. These are things that happen when you've got people who decide to mistreat other members of society. Another example is the accumulation of debt. The fact that we've accumulated $18 trillion in debt within our federal government. Now, there are a lot of people in America today who are not even old enough to vote yet, and before they're even old enough to vote, they own a significant share of that $18 trillion debt. That's a nasty form of taxation without representation. We fought a war over that. We won that war. That's going to have long-term ramifications as well.
William Redder. I refer to the 14th Amendment to the Constitution, in which it is alleged that the provision that anyone born in the United States automatically gets citizenship. Some say it was intended only to apply to the freed slaves, American Indians, and Gypsy. What are your views on that provision of the 14th Amendment on birthright in the United States?
Yeah, great question. Okay, so you're referring to The Section 1 of the 14th Amendment, which provides in pertinent part that all persons born or naturalized in the United States and subject to their jurisdiction thereof are citizens of the United States and of the states wherein they shall reside. I agree with your assessment of what they were intending to do there, and I think that's right. I think it potentially extends even more broadly than that. I do not believe that that is the end of the sentence, however. I don't think that means that it is the only possible construction of that is that you could conclude that anyone born here is automatically a citizen. We know, for example, that we don't count people born to, for instance, diplomats on U.S. soil. They are not they're not considered entitled to automatic birthright citizenship. The phrase that we just read and referred to in Section 1 of the 14th Amendment, the part that says, and subject to the jurisdiction thereof, does some work. That's not mere surplusage. As I read that, that says that Congress has the authority and the discretion to decide what it means to be born in the United States and subject to the jurisdiction thereof, such that Congress can set the parameters for that. Now, Congress has not adopted such a law, but it could. And so you have had proposals that have been introduced that will say, for example, that if the law were enacted, you'd be entitled to automatic birthright citizenship only if at the time of your birth you had at least one parent who was a citizen or a lawful permanent resident or perhaps an alien who was engaged in active full-time military service to the United States. That would be one approach Congress could take, but hasn't taken yet. Yes?
Thank you, Senator. I really enjoyed your talk today, starting out with your personal experiences. I'm curious, a couple things from your talk, the 80,000 documents, the people electing yourself and others for the people representation. What things would you suggest people do? Obviously, your book is one example in learning about the Constitution, but obviously the 80,000 is an example of something that's overwhelming, and for people that are living their lives, they're expecting yourself and others to continue with the government and do the best thing, as Churchill said, ultimately everybody gets to for the U.S. What checks and balances, either through the Constitution, would you recommend be put in place to check the checks and balances for the government? Are the things you had talked about with the NSA documents and the things you've tried to change in the government? But obviously those should have been changed prior to that. So are the things in regards to the Constitution that people can say, hey, let's look at the Constitution before we proceed on this vote?
Yes, and that's a great question. I'm glad you asked that, because in almost every instance, there is at least one potential fix. And the ideal thing is when you can identify a couple of solutions to a particular problem. In many instances, when we see a constitutional overreach, you'll have at least one branch of government that is most directly responsible for the constitutional problem. So the ideal circumstance is to look for a possible solution in at least two of the three branches to that same problem. So for instance, in the case of the excessive delegation of de facto lawmaking power with our federal regulations, I think my personal belief is that the best way to solve that is through the REINS Act or something like it, something that would require these executive branch regulations insofar as they impose obligations on the American public rather than just dictating what time of day the lights in the Department of Energy go on, that they have to be run through Congress. That's a fairly simple legislative fix. Not easy to get it passed, but if we could get it passed, it would fix the problem. Simultaneously, those of us who are concerned about it ought to look for other ways that we could look for other solutions in the other two branches of government. I love the idea, every time I hear about a challenge being brought to an executive branch regulation, anytime I hear of someone contemplating a challenge to an executive branch regulation, based, for example, on an excessive delegation of legislative authority theory. Even though that's difficult and expensive and time-consuming to do, I think that's got great potential. I think the REINS Act has greater potential, but it's good to have that one in there as well. But the more people who are thinking about it and looking for solutions, the greater the likelihood there will be of there being a solution. It's interesting. When I first ran for the Senate back in 2010, so that's been five and a half years ago since I started running for this job, people rarely talked in the sort of town hall setting I never heard from Joe Sixpack about regulatory overreach. Today, it happens all the time. In every hamlet throughout my state, every obscure town throughout Utah, somebody brings up overregulation because it's become such a big problem that people are more aware of it now. They're aware of the economic impact it's having on them, in part because our federal agencies have started being more aggressive in going after not just big businesses, but also small single business entrepreneurships and things like that. And so the more people who are affected by it, the more people will be interested in it and interested in finding a solution. But it's very important for people to look for and identify a solution and then aggressively push for it. Because little secret I'll tell you about Congress, Congress doesn't move unless it has to. We are a very big, immobile beast, and we move only when there's no other way out. So the more we can hear from the people, the more we can hear from people all over the country saying, we want this solved, and we think this kind of thing is the best way to solve it, the better off we're going to be. Okay, I'm told that I'm out of time. Thank you very much for coming today. I appreciate it.